For pronouncement of judgment, item 51 to 57.
With regard to the challenge made to 2003 rules, we have held that those rules are no longer existent and we have closed those writ petition. With regard to the challenge to the provisions of 2I and 2P, we have rejected that. But with regard to the challenge to Rule 13, Vice Principal post, we have said, we have given our conclusions. The government is now to make a review for inclusion of that in the provisions of the rules.
Okay.
Item 58.
May I, my lord, sir?
After judgment. After judgment.
Oh, sorry.
We have rejected the claim of the petitioners and the writ appeal is disposed of.
And so obliged.
For pronouncement of judgment, item 59.
We have held that the CRTE has the power to condone the delay while applying the provisions of the Implementation Act and entertaining an application under Section 17 of the Surface Act. We have remitted the matter to the CRTE to consider the application, and if applicable satisfaction is there, it can condone the delay and decide the application on merits. Obliged.
Yes.
Supplementary 1, item 69 for judgment.
Writ petition allowed, the order passed by the CAT is satisfied. Much.
Adjournment request, if any, from item number 1 to 6.
May it please, Your Lordship.
Yes.
I beg to mention item number 6, Lordship. We have instruction to appear for respondent number 1, Lordship, and yet to receive Okalat number, my Lord. May it be kindly adjourned for today, Lordship.
But there are many respondents who have not been served, 4, 5, 6, 7, 8,
Yes, sir.
apart from one.
I'm for the appellant.
You are for the appellant. Let the number comes, we'll pass in order appropriate order.
Obliged, sir.
We'll mark your presence.
Item number 7 to 12.
May I please, Your Lordship? I beg to mention item number 4 and 5 of the daily list.
Yeah.
In this matter, my lord, senior counsel Kane Chaudhary is engaged, my lord, and he has some personal difficulties today. I pray for an
But
accommodation.
last time the respondents were supposed to clarify the deduction of
There-
rupees 18 lakhs and above.
Yes.
Who is appearing for the respondent?
I'm for the contempt order, Lordship. They have forwarded me
You are for the
Yep.
contempt.
contempt order.
Yeah, so why you have deducted that 18 lakhs rupees?
Lordship, the amount is deducted for TDS, Lordship, and his come into 30% of gross amount.
Clarify it by filing an affidavit. Because it was a specific-
Lordship, I will file that
After a week,
after 2 weeks, Lord.
after a week, you find that clarification, why you have deducted that rupees 18 lakhs amount.
Obliged.
Obliged, Lord.
Item number 7 to 12, adjournment request. No. Item 13 to 27.
May I please your lordship, I beg to mention item 21, lordship. A week's time.
Adjourn.
Declare.
May I please, your lordship? I beg to mention item number 13. I have withdrawn the matter with the liberty to file.
Item number
13, lordship.
13.
Yes, lordship.
Yeah, what do you want?
I have withdrawn the matter with the liberty to file a fresh, lordship.
Why fresh, why fresh?
My senior instruction me, lordship.
Fresh for what? Fresh for what? Last time, you tried to satisfy regarding the maintainability of the PIF.
Lordship.
So why this, fresh, what do you mean by fresh? Simple withdrawal will allow,
Lordship.
will not grant any liberty to file fresh.
Lordship, lordship.
Freshness as withdrawal.
May I please, your lordship? Lordship, I beg to mention item number 14, my lord.
One
My
more, yeah.
lordship, my senior is out of station, your lordship, for only 1 week time maybe. Your lordship, adjourn this matter.
I live, lordship.
Nothing in this appeal. In fact, Leonard Singhal dealt with everything
Lordship, only for 2 days, your lordship, he is out of station, your lordship.
after a week.
Obliged.
Yes.
May I please your lordship, I beg to mention item number 19. We need 1 week time to file and reply affidavit.
Adjourn. Yes,
Wait, please, your lordship. With the consent of the other side, I beg to mention item number 27, today's daily list.
adjourn.
Obliged.
Item number 20.
Yes,
From item number 28 to 37.
Yeah, ma'am. Malad, seek your lordship's indulgence to mention item 32, Malad. I would seek your lordship's accommodation to give me a date fixed in the matter since I come down from Delhi, Malad. So after 2 weeks, so if your lordships could oblige me, Malad, I'll be grateful.
what about this item number 31, who is appearing in the item?
31 is my lordship.
What do you-
I'm appearing, lordship. Same.
31 and 32 are connected.
Connected matters that, Kamakya.
Kamakya related.
Connected.
Yes, Malad. I would like to be personally present, so a fixed date would, Malad, help me in Malad and making.
When?
Malad, any day on the week of the 8th, after 8th of December, Malad, that week.
In his second week of December.
Yes,
11th of December.
I'm grateful.
11.
Grateful. Grateful. Malad.
With regard to item number 38 to 42, your lordship, with due consent from the other side, I beg to mention the matters. 38 to 42. We have some,
What do you want?
we have some personal difficulty today. Let the matter may come up after 2 weeks. your lordship.
4 weeks.
Must-
May I please your lordship, I beg to mention item number 33, your lordship. I am for 33, your lordship.
33, yeah.
I am for the respondent number 3, your lordship. Due to some medical emergency, I could not file the affidavit. Kindly grant me some time, your lordship.
2 weeks.
Deeply obliged, your lordship.
Any other request?
Your lordship may please serial number 60 in supplementary list, your lordship.
60.
60.
Yeah.
yes.
What do you want?
Your lordship, it's an urgent matter and IA has been filed yesterday, your lordship. Your lordship may permit along with this, your lordship,
Call for that.
today. It will be taken up today, your lordship.
The matter will be taken up today, then certainly the IA would also be considered today.
Yes, your lordship. Deeply.
May I please, lordship? With due consent of other side, lordship, I beg to mention item number 46, 47, 48, and 49. Kindly pass over for today, lordship.
2 weeks.
Obliged, Lordship.
May I please Lordship, I beg to mention for listing contempt case. Kindly list the matter next week, any.
Next week.
With the consent of the other sides, my lord, I beg to mention item number 50 of the daily list, my lord. I pray for an adjournment, my lord.
Yeah.
Obliged, my lord.
May I please, your lordship, as per instruction from the petitioner, your lordship, I prayed for withdrawal, your lordship. Item number 43, your lordship.
43.
Yes, your lordship.
This is adjournment slipping. You want to withdraw?
Yes, your lordship.
Wants to withdraw. Dismiss and withdrawn.
Obliged, your lordship.
Any other requests? Daily list for orders, item 1.
Now, this writ appeal was already admitted on 4th of April. The dusty service also has been effected when you file an affidavit.
This filed on behalf of the appellants. Stating that the notice issued upon the sole respondent has been served personally to him. Stop. The copy of the notes, the copy of the notice along with the signature, the bearing signature of the respondent to the is annexed with the affidavit. In such circumstances, the service of notice upon the sole respondent, upon the respondent number 1 is needed to be complete. There's this writ petition for admission after 2 weeks.
And it's already admitted,
Already.
my lord, on 4th of April. Lordship, you proceed for hearing in the usual course, my lord.
Since the petition is already admitted, let's look for hearing in due course.
Item number 2.
You have not taken any steps for respondent number 9.
My lord, today I have taken step, my lord.
Counsel appearing for the the petitioner undertakes to take fresh steps to take steps for service of notice upon the respondent number 9. On taking such a step that notices will be issued to the respondent number 9 by registered AD post with registered AD post registered post with AD as well as the state returnable 6 thereafter.
Obliged, man.
Item 3.
Yes, 4 and 5 not served. That's why, Rashid, I appear for the respondent number 4. That is Union of India Lordships. And I have prepared the affidavit I have sent it for signature Lordships. 5. Rural Development.
5 is the standing council PNRD.
Who is the standing council?
PNRD, Panchayat and Rural Development, my lord. PNRD is
Who is the council?
my lord,
Yes,
S.
Dr.
Dr.
As per the office report, notice upon the respondent number 4 and 5 has not been.
Also,
Mr. R.K.D. Chaudhary is appearing on behalf of the respondent number 4. Mr.
I am for the 1, 2, 3, and 6.
M. Datta. S. Datta is the standing counsel for the Commissioner Panchayat, for the respondent number 5. And a counsel for the petitioner is directed to supply copy of, to supply the copy of the notice along with the petition to Mr. Datta.
Yes,
During the course of the day.
yes, Lordship, I'll do that. Humbly, I will press for interim, Lordship, because already I have served to other respondent. Main respondent is here, Lordship. So interim.
My lord,
Because
so
it's
for
a
allegation of the petitioner is concerned, my lord, the Director of Social Welfare directed the, my lord, district officer to make an inquiry about the, my lord, allegation made by the petitioner. We are waiting for the inquiry
By
report.
what time you will file the response?
My lord, 3 weeks, my lord,
Lord,
3 weeks, my lord. Because, my lord, inquiry has been directed to.
For the respondents are
Ma-
directed to file response to the writ petition by the next date of hearing. This second week of December.
Obliged.
deeply obliged.
12 December.
Deeply.
Item 6.
Lordship, I am appearing for respondent number 1, Lordship. I have to file local number today, Lordship.
Mr. So-and-so put in appearance on behalf of the respondent number 4.
One, Lordship.
Respondent number 1, let the await return of notices of respondent number 4, 5, 6, and 7.
I've got 2 and 3.
Await return of notice of respondent number 4, 5, 4 to 7. 4 to 7 for 3 more weeks.
Yes. Item 7.
May I please your lordship? I have instructed to withdraw this petition.
Wants to withdraw this. Yeah. He wants to withdraw this idea. The consequently, the writ appeal number 2527/2024. Want to withdraw this idea, dismiss as withdrawn. Consequently, the writ appeal number 2527/2024 filing number is also dismissed.
Item number 8 and 9.
So far as item number 8 is concerned, that is IA 1047 of 2024. My lord, there is a application leave, allowing leave, because certain documents we want to bring notice, which was before the learned single judge, because there has a connection with judge. And I think my learned friend should not object to that. I don't
Learned single judge.
learned single judge.
Only on
I'm sorry,
documents
yes.
that were not part of the writ petition on documents which were. They were not before the learned single judge.
My lord, this was not at that relevant time, it was not a part of the writ petition. During the course of deliberation, when the argument was advanced, my lord.
Lordship, a paragraph 12 of the judgment that the document sought to be
Paragraph
12 of the judgment at page 2.
230, my lord. That document has been considered, my lord, in fact.
At page 230, my lord.
What's the
So,
controversy about?
this is about the tender which is floated by the Forest Department under the Assam Minor Mineral Concession Rules, my lord, 2013. That is for a period of 7 years. Now, my lord, technical bid as well as financial bid. There were two bid systems. 3 rounds of litigation. First round of litigation, my lord, technical bid, he was not qualified. So he comes to the court. And the court direction was that it should be reconsidered, technical bid. Now the authority reconsidered. Second round again he comes to the court. Technical bid again was rejected. Then third time again the court said no. The problem the court said here that my lord these are all online. There are two. One, online you have to just upload it and the physical documents will be placed whenever they want to. They want from us. Now the online certain documents were not placed by them. That's the whole case by them.
Para number 12.
12, yes. Although no, at page 230, my lord. Although no affidavit was found in the present proceeding by any respondent, but during the course of hearing certain document were placed before this court, reference to which this court find it pertinent to mention. These documents were placed, the learned say appearing on behalf of private respondent. The first document is a document dated 26/8/2022, whereby Divisional Forest Officer Lakshmipur has informed the private respondent and Ganesh
These are
Kalkar.
the documents which you want to place.
Yes, why? The learned single judge said technically, when technical bid was over,
But
no, my lord,
Learned single judge has taken.
no, why learned single, there was, with great respect to learned single judge, there was an error which I will place when placing the document. My lord, there were two bid systems.
Here this application is for taking on record.
Yes, that's all,
these
that's all.
documents, But these documents have already been taken.
Placed, my lord,
By the learned single judge.
Yes, it was placed, my lord, over across it was placed. Well, lordship will hear the appeal.
Matter comes upon for consideration of the application, the SIA numbers were preferred on behalf of the applicant with a prayer to take on record certain documents. Which stop, it is noticed that those documents were taken into consideration by the learned single judge in the impugned order in para number 12. Since the learned single judge has already taken into consideration those documents, we deem it appropriate to place, to take on record the documents annexed along with this IA. The IA is disposed of.
Yes, that's all. Yeah. My lord,
There are
appeal
two
should be, one is, my lord, there are two cases, but there is a common judgment. Common judgment. Yes. My lord, this second case, this is notice has been sent, I think it is answered. I think we have to take a fresh step.
Let us see.
Read
since
appeal,
that
let it be numbered. Read appeal
itself-
numbered.
Appeal itself is not for orders. Let us.
Let us number, read appeal number. I'm sorry.
There's delay.
No, there's no delay, no delay. My lord, this why I am conscious about the para 12 of the judgment. Because the learned single judge view, once your lordship looks into that, the learned judge view was that the technical bid only at the time of financial, there was one bidder only. There was no two bidders. That's one of the ground, one of the judgment that has been dealt. So if I can show that there were two bidders, everything was over. That's the whole point which I want to.
We have already taken.
Yes, correct. Right. Only a very lighter vein. I was just watching behind back and your lordship was pronouncing the judgment one after another. Then I was just recollecting my those school days. When we were in school, class 5, 6, that time those judgments, roll number 1, you have passed. And I just thought that these days it should be over by class 10 and up to my LLB. There the same thing is happening now also. Again, same thing is happening now. Never ending. I am deeply obliged.
Item 10,
Please, my lords, I beg to appear through VC for the appellant, petitioner appellant here in my lords. My lords, in terms of the order 25th of June, this honorable court had directed awaiting return on notices on respondent number 7 to 9. Pursuant thereto, we filed an affidavit of service showing that the service is
Just a minute, 25th of June.
25th June 2024, my lords. I can read that order. Await return of notices on the respondent number 7, 8, and 9 for the 4 more weeks. List after 4 weeks.
Await return of notice, yes.
Yes, my lords. Pursuant thereto, my lords, on 7th November, we have filed an affidavit of service after taking the consignment numbers of the postal dockets from the desk pass section, which shows that service is complete. Those tracking reports, my lords, may see at page number 16 onwards, and tracking report is from page 19 onwards.
Just a minute. Nikhil.
Yes, my lords.
And what about 9?
9 also, my lords, it's there. Page number 22.
Okay, Nikhil, and the concept of the applicant has submitted the service of notice upon the respondent number 7 and 8, 7, 8, and 9 has already been affected, and in support of and the tracking report has already been placed on record by way of an affidavit filed on 7th of November 2024. Lalima Court is directed to take into consideration this tracking report and thereafter place a report before this court within a period of 1 week.
Most obliged, my lords.
The date may be fixed, Milad. This pertains to Maujuj, Milad, and you will come in January.
After we've already fixed after 10 days. They can be there.
Most obliged.
412.
Very-
Item 11,
Another bench. Circle it. Then I'm.
most obliged. Another one. Item 12,
I plead your note. There is a delay of 13 days, so many notice may issue.
Notice. AD must be.
item 15,
Maybe. My lord, the issue before lordship is that, my lord, whether in exercise of lord power of review, whether the learned single judge could have stayed its own order. My lord,
Get the review decided because there is
So there
something.
because my lord, contempt was also pending. My lord.
Whatever it may.
Now the
Get the review decided because now the state has come with a specific stand that whatever the list which you have produced before the learned single that was a forged one. Then at
Not-
least,
My only humble submission is, my lord, whether a stay could be there because there could not be a stay, my lord. Stay is can only.
an appropriate bypass. If apparent, something is apparent on the record that the learned single just after taking into consideration a list which is not at all in existence, your name was not there.
It was there, my lord. The name, my lord, while filing the review, another important aspect which I may point out, my lord, the affidavit which the state have filed, they have not annexed that affidavit.
Which affidavit?
The affidavit in opposition filed by the state, my lord, they ought to have first annexed their pleadings in the review.
You raised this point before the review
That's what, my lord.
judge, that this is what the lacking. Otherwise, if again, then once the learned single judge state that now we are saying that again, it's.
Lord, may I pray, my lord, it can be kept as suspended, my lord, the word stay may not.
Maybe
My lord.
in in ordinary case, the learned single judge should not have stayed his own order. But in the facts and circumstances of the case, it appears that what else order can be passed.
My lord, may,
If it is true that that application itself was the select list was not in existence, your name was not there. And relying on that, a select list which is as per them was the forced one or not the actual one.
those
Certainly,
those
better
issues
requires-
were not heard, my lord, on the first date itself. Actually, my lord,
The
If
date
my
was
lord-
fixed, next date was fixed on.
no, it has not been listed thereafter, my lord, after 25/6/24. Because, my lord, indirectly, my lord, the contempt which we have filed, that was pending for 4 years, my lord.
That's right.
We were trying to, and the undertaking was given by the council, my lord, to comply with the orders.
If the fact says that list was not at all in existence or that was a forced list. But then is some.
My lord, during the
Requires some-
contempt proceedings, my lord, there was a specific statement made by the state council stating that they are going to comply by the order. And even after giving assurances, my lord,
Place all these facts before
My
the review judge. Will Consider
lord.
this.
my only prayer, my lord, is to, my lord, maybe it may be suspended, but stay would be on merit, my lord. It can only be granted by a higher court, my lord.
Pursue or review.
My lord, my lord, may make an observation, my lord, for expedient disposal of the, my lord, review.
After attending to the matter for quite some time, when I contacted the petitioner on instruction submitted, the review petitioner on instruction, sorry, appellant on instruction has submitted that he does not want to press this petition over. Seeks liberty. But, I would say that the review petition preferred on behalf of the state may kindly be disposed of expeditiously. Review petition number 105/2024 preferred by the state may kindly be disposed of expeditiously. Stop. In view of the submission made by the non-counsel for the appellant, this appeal is dismissed as not rest. However, the registry is directed to list the review petition before the concerned bench. Review petition number 105/2024 before the concerned bench. Within a period of 2 weeks. Before the concerned bench. Within a period of 4 weeks as in that. The bench is available.
My lord.
Item 16,
File the response.
Lordship, similar matter has been already dealt by Honorable Patna High Court and has been dismissed. Lordship, similar facts and circumstances, they have challenged the rules because, my lord,
My friend may give me a copy.
I'll give the number. Civil number 8978/2020. Internal page 13, there is Honorable Court observation.
Para number 13.
Lordship, internal page, my lord, having heard learned counsel for the parties. Okay.
When you file your response
My lord,
and supply the copy.
yes, Lordship, I have this.
Concept appearing for the respondent. They submitted that a similar challenge to the rules of which are the rules?
Well, it's P5. These are the Assam Transport Service Rules 2003.
A similar challenge to the Bihar Transport Service Rules 2020 has already been dismissed by the Patna High Court. While its judgment dated 18/10/2022 passed in civil writ jurisdiction case number 8978/2020. It is submitted that the provisions of the Assam
Assam Transport Service 2003, my lord.
Assam
Transport Service Rule 2003.
Transport Service Rule 2003
Lordship,
2003 are perimeter to the Bihar Transport Service Rules 2020. Stop. When the concept of the state, please some time to file counter to the restitution time period for is granted. Next after
as per my lord convenience, I would. I'll be within 10 days, my lord.
2 weeks.
Deeply obliged.
Item number 17.
Why you have not objected when this notification was issued at the first instance?
We raised objection, my lord. In writing, we raised objection,
That,
but that was not dealt with.
where is that? Your objection?
It's annexure 3, my lord.
Page.
Page 35. But basically, Now the whole exercise we are challenging, my lord.
Sir,
is the Assam.
where is that specific that you can't, this acquire the land by invoking the provisions of 1964?
No, that challenge we have not made, my lord, in our objection.
Then now
But-
now everything is over, now the award is passed. Then you are then make a reference.
My lord, but the day the new act 2013, the Right to Compensation Act came into force, my lord, this act become repugnant, my lord. So that
And
challenge, whether I,
You should raise this point at that.
My lord, this is a-
Time when the acquisition proceedings are over, now you are raising this point and by way of PIL. Why, where are the aggrieved persons?
this is not PIL, my lord.
It's not PIL.
We are challenging the law itself because this has become repugnant, my lord, by the day the 2013 Act came into force, my lord.
Came into force, then where is your objection to this effect?
My lord, whether I
You have
raise the objection,
participated in the, you have filed your objections regarding other thing, when the award is passed, now the only.
my lord, may I place my lord? Whether I can raise this kind of objection before the deputy commissioner, my lord, before the deputy commissioner, under the Assam Acquisition and Requisition Act, I am to only show whether the land which is being acquired or required by the government, my lord.
Kindly consider.
My lord.
sir, even though you can't raise before the deputy commissioner, but who prevented you to approach this court at that time?
My lord, thereafter, there was total lull. There was total silence from the side of the
When
government.
the award was passed.
We have been notified only in 2024, my lord, that
Award,
too.
award, sir.
We were not notified, my lord. We were never intimated, my lord. On 19th October, my lord, we came to learn about it in May 24, my lord, when we made the right application under RTI. And this is a very important legal issue, my lord.
Representation itself is of 2018, my lord. Representation itself of 2018.
My
Under
lord.
those requisition proceedings, any award was passed?
I'll have to get the instruction.
You should have get the inspection at the first instance, and then you receive the writ petition.
Hmm. My lord, may I take your lordship to paragraph 10? Page 10. The requisition was done in the year 2018 and the final order of acquisition was passed in
They must
2022.
have followed that procedure prescribed under the Act of 1964.
No, my lord. Even that was not followed. Had that been followed, we would have come to know. We were only intimated that the government is going to require the land. But when it was actually acquired, we were never intimated, my lord. And we came to learn only after making application under RTI when we started looking and finding that nearby people are running for getting compensation, then only we came to learn. And my lord, may I place, whether I get relief or not before this honorable court, the legality has to be tested, my lord.
This, there is a land acquisition act. Assam Land Acquisition and Acquisition Act 1954.
There are two distinct parts, my lord. Section 3, which deals with requisition, and Section 6 is about acquisition. So far requisition is concerned, my lord, I was informed, I raised my objection, that is under section 3. Section 3 reads, my lord,
Just a minute, please. That petition, 2013 Fair Compensation Act.
Welcome.
So in fact, now come to this Article 254.
my lord. So for
You have to demonstrate the repugnancy between the two acts. Where is that, sir? Where is the pleading?
that pleading is there, my lord.
Where is that pleading, sir?
Paragraph 21 of my writ petition, my lord.
Read.
Page 17, my lord.
Yes.
That the petitioners also challenge the procedure adopted by the state for acquiring land under the 1964 Act instead of the procedure prescribed in the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. The present petitioners and the other pattadars in the instant case would not have suffered from the lack of transparency and violation of their basic human rights if the procedural safeguards under the 2013 Act would have been applied instead of the 64 Act. It is stated that the 64 Act has to be deemed to have lapsed and become void on account of repugnancy with the 2013 Act. Both the acts cannot operate in the same field as both the
That's right.
legislation.
This is your submission, but what is the repugnancy?
Yes,
What you have mentioned in the, where is that in the pleadings? If this is what
the entire act has become repugnant, my lord.
Entire act can't be.
My lord, let me submit my lord.
254(1).
Let,
254(1).
my,
Article 2.
if any provision of a law made by the legislature of a state is repugnant to any provision of a law made by parliament, which parliament is competent to enact, or to any provision of an existing law with respect to one of the matters enumerated in the concurrent list, then subject to the provisions of clause 2, the law made by parliament, whether passed before or after the law made by the legislature of such state, or as the case may be, the existing law shall prevail, and the law made by the legislature of the state shall, to the extent of the repugnancy, be void.
So to the extent of repugnancy,
My lord.
you have to demonstrate, sir.
I do agree, my lord. Let me place my lord. My lord, what is the objective of the 2013 Act? Acquisition and requisition are subject of concurrent list. There cannot be any doubt under entry 42, my lord. So both parliament and the state government, both are competent to legislate. So for the 64 Act is concerned, my lord, it is prior to 2013 Act. Now, what is the objective? Before I come to that, my lord, kindly look at the objective which wanted to be achieved by the 2013 Act. Kindly have a look, my lord. First of all, the acquisition is for the purpose of aims, my lord. Kindly come to section 2 of 2013 Act, my lord, subsection 5, which is covered, where this act will be applied. Project for government administered, government aided educational and research scheme or institution.
2.5.
2.5, my lord, Roman 5.
Project for government administered, government aided educational and research scheme of the institution. Yes.
Yes, it is covered now, my lord. So far aims is concerned. Now kindly come to the objective part, my lord. Statement on objects. Para 1, my lord. The Land Acquisition Act 1894 is the general law relating to acquisition of land for public purpose and also for companies and for determining the amount of compensation to be made on account of such acquisition. The provisions of the said act have been found to be inadequate in addressing certain issues related to exercise of the statutory powers of the state for involuntary acquisition of private land and property. The act does not address the issue of rehabilitation.
Ultimately, sir,
My lord,
unless you
give me 2
demonstrate
minutes.
the repugnancy.
I am showing that, my lord.
What we,
So,
sir, you
my
have to
lord,
plead.
this statement, my lord, has some relevancy. I will come
No
to
doubt
that
about it.
subsequently, my lord.
No
Kindly
doubt.
let me place one judgment, my lord, of the Honorable Supreme Court. Some relevant portions, my lord. 2021. Yeah, 231.
One have.
AIR online 2021 SC page 231. This is Forum for People's Collective Efforts versus State of West Bengal. Kindly come to paragraph 74, my lord.
Page,
It will be page, my lord, 87. There are three distinctive features to be looked into in order to find out the repugnancy, my lord. And the second distinctive features will be applicable in my case, my lord. In assessing para 74, my lord, whether this overlap between the statutory provisions of this is West Bengal Act, my lord, and RERA makes the former repugnant to the latter within the meaning of that expression in clause 1 of Article 254, it becomes necessary to apply the several tests which are a part of our constitutional jurisprudence over the last 7 decades. Repugnancy can be looked at from three distinctive perspectives. The first is where the provision of a state enactment is directly in conflict with a law enacted by Parliament so that compliance with one is impossible along with obedience to the other. Second test that is applicable in my case is where the Parliament through the legislative provision contained in the statute has enacted an exhaustive code. The second test of repugnancy is based on an intent of Parliament to occupy the whole field covered by the subject of its legislation. I'm not going to the third, my lord. That is not applicable in my case. So for the
still it is
in terms of the second test of repugnancy, a state enactment on the subject has to give way to the law enacted by Parliament on the ground that the regulation of the subject matter by Parliament is so complete as a code so as to leave no space for legislation by the state.
we understand, sir, that is the position of law and what we are saying. Yes, it can be, so far it is repugnant, the state act is repugnant to the act made by the Parliament, it is treated to be void. But what is the repugnancy? At least you should point out, sir.
I am pointing out, my lord.
So pointing
Now,
out
so
in the
far-
pleadings, sir,
My lord,
in the pleadings.
my lord, so far 1964 Act is concerned, my lord.
Yes.
It doesn't take into account the social impact on the
That's
displacement.
why
my lord.
only, sir, please plead it. So at
And
least we
so
can,
I will have-
consider that.
I will-
You please plead in your petition. Then we'll consider that it is repugnant to this extent or whole
No,
extent. or-
as a whole, my lord.
So that's why only, sir, plead it.
My lord, let, my lord, elaborating the second test, my lord. My lord, I will be showing two more things, my lord. Because the entire act I am trying to show, my lord.
We fail to understand, sir, why you are trying in pointing out the specific repugnancy. What's the problem?
The entire,
Sir,
the entire act, my lord.
sir, entire act, even though if the entire act is repugnant, please make some
So I will
pleadings
have to-
should be there, sir.
That the 2013
Why,
act in itself, my
simply
lord.
Since the Parliament has made an enactment, until and unless it is you demonstrate the repugnancy, how can we come to a conclusion, sir?
So 2000, so far 64 Act is concerned, my lord, it doesn't take into account the rehabilitation, the resettlement, and the displacement part. The social impact doesn't,
So plead it, sir.
we have
Plead
pleaded.
it.
My lord, I am not saying that this particular provision or that particular provision of 64 Act has become
Yeah, sir,
repugnant.
for the
I
purpose of-
say that as a whole, the moment this 2013 Act came into force, my lord, because the 2013 Act within itself, my lord, is a complete code. So for, my lord.
What my lord is trying to, because
My lord.
we understand there is a reflection. But at least you will have to demonstrate in your petition that this is the act This is the 64 Act and this is the 2013. 64 Act does not cover these aspects. At least bring in a statement with the judgment of this bench pertaining to the Mizoram Land Acquisition Act.
We will file an,
We are-
I can understand. I have got the point, my lord.
So that act we have held.
In a comparative table, my lord, in a-
Otherwise, it would be very difficult for us.
I
to-
can understand.
At least you make out the case, you plead it,
In a comparative,
at least they would also know, they'll also file a reply to this in response to that, then we'll judge it.
we'll file additional affidavit, my lord, giving the comparative table as to how, why.
Sir, you have to give, that's why, what I am communicating, if you have not been able to.
I am so
understand,
sorry, my lord. I am so sorry.
I fail, but,
I am so sorry, my lord.
still I'm concerned for the petitioner place some more time to place on record the points of repugnancy between this West, Assam state, Assam Land Acquisition and Acquisition Act 1964 and the right to fair compensation and transparency and land acquisition, rehabilitation and resettlement act 2013. When,
On any particular date, my lord, as is convenient.
yeah, what is your convenient date?
19th December, my lord.
In December.
Highly obliged.
Item 18.
18 is same, my lord. Same. 18 is same.
Item 20.
To dispose of similar petitions. While not treating it as a PIL.
Lordship, because there in that matter, some of the land that was in issue, they were, they had already come as petitioners in a different petition before that,
Whatever it
Lordship.
may be.
But in
But
this case, Lordship, this is a bona fide
ultimately,
PIL, Lordship.
This PIL, then why the persons who are affected, how they are not able to approach this court in their individual capacity?
Lordship, because of ignorance and poverty, Lordship.
That can't be ground in,
Lordship,
take
and
this ground in every case.
yes, Lordship,
It's
but
a-
then in
it's a
this case,
private- In fact, it's a private right, how much compensation is to be paid, to whom it is to be paid, that is altogether a individual
not,
case, an individual
Lordship.
grievance, not of general grievance.
Lordship, it is not only about how much compensation, Lordship, whether they can, in the beginning, even acquire the land, whether the process has been followed, whether our land has been acquired or not, because it is a non-cadastral land, Lordship. They do not know where they have allotted the land. Few days ago, there was even violence because the villagers thought that they were earth cutting in their land, and then one of the executive members of the council, he took the weapon of the PSO and fired live shots, Lordship.
That, how can that be influenced, that this? won't be
Lordship,
influenced
fear
by
also,
those
Lordship.
incidents?
It is not only poverty and ignorance, but even fear, Lordship. Lordship, the revenue department has filed a affidavit.
That you can't file a PIL for that purpose. That is the individual cause, not on two villages. If the villager, their land is being forcibly acquired, they can very well approach in their individual capacity, not as a PI.
Lordship, but then this is happening everywhere in Dima Hasao, Lordship. This is not an isolated incident,
Everywhere the
Lordship.
person has to approach the court in their individual capacity, sir. You have simply said, since they are ignorant of their land rights, therefore they are not able to approach this court. That can't be the ground only, sir.
Lordship, but it is also poverty and then this fear of the administration itself, Lordship.
Fear of the administration, and you are also of the same reason. You are not, you don't have any fear from the authorities.
Lordship, I don't stay in the villages, Lordship. That is the only difference, Lordship.
You are not staying in the villages.
I am staying in the district headquarters, Lordship.
That can't be. That is,
They need someone to help them, Lordship. That is why he has
you can
taken
very
up
well-
this issue,
you can
Lordship.
very well guide them, file an individual case for them if you are really want to support them. Because in general, we can't do this roving and fishing inquiry.
Lordship may also
How many
consider
land
the,
is there, how you are entitled to hold this land, that is, you are pattedar or what? Every case has to be satisfied on its own facts, sir.
yes, Lordship. Lordship may also
Only it's
consider
not
the
a case
counter
of-
filed by them, Lordship.
Yeah.
Lordship may also consider the counter affidavit filed by them, Lordship.
Why counter affidavit? Where is
They
the
have
counter
filed.
affidavit?
Filed by the respondent, Lordship.
Yes, what is it?
Respondent number 5 has filed the affidavit, Your Lordship.
Who is the respondent number 5?
Revenue, Your Lordship.
Additional
Additional
Secretary.
Secretary, Revenue
Yes, what is
Department.
your response?
Lordship, we have, I want to bring Your Lordship on paragraph 7, Your Lordship.
Read.
See, our candidate get the,
Read.
yes, Your Lordship. That the deponent begs to state that as per resolution number 12 of the executive committee meeting held on 5/9/2024 in the conference hall of the Honorable Chief Executive Member Dima Hasao Autonomous Council, Haflong, the land measuring 3,000 bighas situated all along in Gorompani Lanka Road in between 26 kilometer and 29 kilometer Umrangso Dimahasa, which was earlier allotted for establishment of industrial estate is hereby re-allotted to MS Mohabal Cement Private Limited at Umrangso for setting aside the cement plant. Therefore, the land which was allotted earlier, allotted by office notification number so and so, dated 2nd March 2024, which is the subject matter in the instant PIL to the Mohabal Cement Private Limited at Umrangso stands cancelled. The deponent creates leave of the honorable court to produce the minutes of the meeting. Lordship, in paragraph 8, we have stated that in view of this, the present PIL becomes infructuous, Your Lordship. Because we have not touched that land, Your Lordship. We have cancelled that allotment.
And what remains?
Lordship,
Nothing remains.
Lordship, we have received a RTI reply from the Department of Industries, Lordship. They are saying that the location is not in that area, Lordship. It is in a different location, Lordship.
Which?
This location, Lordship, they have said that now they have allotted the land at between 26 to 29 kilometers Umrangso, Lordship.
Yeah.
And Lordship, we have received the RTI reply from the department
The
itself.
deponent begs to say, for executive committee 592,000 in conference hall, because the land measuring 3,000 bighas situated all along Garampani Lanka road in between 26 and 29 kilometer Umrao, which was earlier allotted to establish industrial development, is hereby re-allotted to Mahabal Cement Private Limited. In Umrao, so setting up a cement, therefore the land was earlier allotted by the order dated so and so to Mahabal Limited instant cancel. The deponent paid to leave. So earlier some land was allotted to this Mahabal Cement. White order dated 2nd of March 2024, against which they have come.
Yes, Lordship.
Now that has been cancelled.
Now it has been cancelled. They're saying that they have now allotted the industrial estate land, which is at 26 to 29 kilometers.
Fine.
So we filed an RTI to the industry department, and then they have said that their industry land is 800 bighas at Longklam village from 15 to 16 kilometers Umrangso, Lordship. It is not at this same location, Lordship. It is at a different location.
So how now you are concerned? Your land, whatever the land for which you have raised, that has been cancelled. Then how you are concerned?
Because they're still on our land, Lordship. Physically, they're still on our land. That is why that violence occurred, Lordship.
Finally, an individual case. We can't ascertain this in haphazard manner. 80% of the affected families, they have paid the compensation, whether they have received, they were forcibly given that compensation or voluntarily received that. Affected families can come, not by way of PIS. It's very difficult to ascertain each and every aspect. Can withdraw it and file an individual case. Anything.
Lordship, we are actually afraid that is the problem, Lordship. We are afraid that we will be vindictively targeted.
And you can very well assess them since you have filed the PIF. You can very well collect those documents and file that. Was the problem at that? It's very difficult to ascertain everything. Simple, 80% of the people affected families, entire families, whether you are the pattedars, you are the possession holder, what is your position, sir? You have to clarify it.
Lordship, we have given a list of the Jirat tax, Lordship.
Whatever
Because-
it is, sir, zero
yes.
tax and so you have to connect. What do
Because-
you want?
Because in that area, there is a.
Now, what do you want? We are not going to entertain such type of thing. Try to understand. If you want, you can seek liberty to file
Lordship,
individual case on behalf of the affected person,
Lordship, liberty may be allowed, Lordship.
having argued the matter for quite some time, let me consider further. He wants to, he does not want to press this petition at this stage, however, seeks liberty for the affected persons. Well, seeks liberty for those persons affected by the acquisition of the land in Nobdi, Long Pukro and Choto Lapang villages at Umrangsko, Dima Hasao, whose land is sought to be acquired by the Autonomous Council, North Kachar Hills Autonomous Council, for allotting it to, for allotment to a private company for establishment of cement company. Well, cement plant. Dismissed with liberty as straightforward.
Obliged.
Item 22.
In this matter, your lordship, I have instructions that we would require 2 weeks further time, your lordship, to submit better particulars, your lordship. 2 weeks, lordship, if not, lordship can dismiss.
And granted 3 weeks time to it. Chief instructions as chief instructions as observed by this court on
6/11/2024.
6/11/2024.
Lordship. Lordship.
Item 33.
Lordship, we are
Yes.
Lordship, we are seeking an additional 2 weeks time, Lordship, to file a counter for this appeal.
Then a requirement of filing a counter.
On last occasion, your Lordship had asked us to file it. Otherwise, Lordship, we had contended that Upendas is covering this case.
Lordship, as per last order, PH department was supposed to file counter affidavit.
2 weeks more time is granted to the state to file counter affidavit.
Item 34.
Wait, please, your Lordship. In this case, we are supposed to provide the procedure, your Lordship, for termination. Correct. This is the SBI HR handbook, your Lordship. Under this handbook, your Lordship, the procedure of termination is regulated for the sub-staff of the bank official, your Lordship. In chapter 2, your Lordship, I have marked with flag mark, blue flag mark, your Lordship. Page 71.
Probation, confirmation, extension, retirement, resignation, etc.
Lordship, chapter 2, it is in page number 71, your Lordship.
Yes, sir. Yes.
Your Lordship, if I may be permitted, I want to bring a notice. to a
Please, we'll ask you, then only.
Your Lordship, if you kindly see the last paragraph of page number 72
Read.
of their handbook. Page number 72, the last paragraph, Your Lordship.
Read.
It is according to a circular, this voluntary cessation of employment. Whereas that is the present respondent was in service up to 2022, sorry, Your Lordship, 2002. That means it was not applicable at the moment he was in service.
Last
And-
para, what do you mean by last para?
The last para of page number 72.
To stem the legal dispute, the employee concerned is given opportunity, it is a report back, duty explain his actions to the bank. How this will help you, ma'am?
Your Lordship, this entire is as this because he was in service up to 2002.
Right.
But it is applicable only from 2000, according to them, it is 2005.
This is applicable. You mean to say that this clause number 2.7?
Yes, Your Lordship.
No. This is simply they said additional some, you have to give him a notice. That's what it says only. Otherwise, voluntary cessation is already there. It is already there.
Your Lordship,
Now you can, at the most, you can ask for this, whatever it may, PF, gratuity, pension and leave encashment benefits. As per this modification dated 21/12/2020. That she is entitled for that.
Also, the PF gratuity has been already been paid, Your Lordship.
Already paid.
Your Lordship.
What about this pension and leave
Regarding the
encashment?
pension part, Your Lordship, the pension rules of the State Bank of India. Page 17, Your Lordship. Page 17. Rule 21, Your Lordship.
Pensionable service.
Pension. No period of leave granted without leave salary or of absence without leave shall count as pensionable service. Your Lordship, 20 years is required for entitlement of pension.
Pension fund to which
Lordship,
You had given us the code.
Lordship,
It was formulated in 2003.
Lordship.
Was this provision of 2.7 existing as of 2002? And if so, what is the limit? Because
the-
here, if you come to the, first page.
Lordship.
The
2000
similar provision was there in the earlier recruitment policy or not?
As per my instruction, it was there in 1989. The first policy was there.
But this is what we have shown us is of
2005, Your Lordship.
Page 2. Page two.
Lordship. In that case, Your Lordship, I have to obtain this instruction. And even if Your Lordship, for a moment, if we consider that his services up to 2016, but he was unauthorizedly absent. So now the question here is, Your Lordship, regarding the entitlement of pension, Your Lordship. And as per the pension rule, Your Lordship, even if we consider that he is in service till 2016, otherwise also, Your Lordship, is not eligible for that, Your Lordship. Because till 2016, his service was 17 years.
2016 and 17 after good receiver.
17 years.
2002 like a 17. 2002 to 17, 85 to 2002.
I'm not calculating.
But this pension rules is of 2014.
Your Lordship.
What is the position prior?
And and the petitioner's husband, he had expired in 2016, Your Lordship.
The service terminated in 2002.
Your Lordship.
Session 2002. So he is not an employee after 2000.
Lordship.
So everything will be as of 2000. What was the position with regard to pension of that?
Your Lordship, at that point of time also, this was prevalent, Your Lordship.
2014.
No, sir, Your Lordship, for a moment, if we consider that because the petitioner's husband died in the year 2016, even if we assume that he is in service till 2016, even then he is not entitled, Your Lordship.
You have prevented him from 2002. If we hold that 2002 to 2016, he was prevented by you. That period gets referred. So he'll be getting, so you will have to speak to 2002.
In that case, Your Lordship, sometime may be given.
I think 2 years or 16 okay. 16 and 32 years.
Yes, ma'am. And you have to satisfy that this provision of voluntary cessation was not in vogue in the year 2002. You have to satisfy.
If required, I will, Your Lordship, but before that, I would like to just make some submissions, Your Lordship. From 1985 to 2002, my service period was 17 years, 1 month. That means I'm automatically entitled to voluntary retirement scheme. That part is never given to me.
Voluntary retirement scheme, whether you applied for that?
Your Lordship, I have applied for pension, but
After the death of your husband.
Yes, Your Lordship, but
your husband, while he was in his lifetime, has ever applied for voluntary retirement?
No, Lordship.
So?
But I have applied for pension. But my pension, why cannot be taken as applications for, because the fact is that my husband rendered service and that fact cannot be denied.
He's right. Your husband, if rendered services 17 years, is entitled, certainly he'll get the pension. You'll get the pension. But for that purpose, what they are relying on that you have voluntarily retired from or voluntarily give up your service, since you are not present after two notices issued to you and as per clause 2.7. Now, whether this either for that purpose, you have to show us that this clause 2.7 was not in vogue in the year 2002.
Your Lordship, 2002. That part I will have to go.
You have to go. Then
Yes, Your
only your
Lordship.
case can be built up.
Yes, Your Lordship, I will have to go by that part. But I was actually from the very beginning on sticking to voluntary pension scheme. Because though I have not applied for the scheme, but
If that is not there, and what was the provision this prior to 2014? What was the provision regarding this pensionable service? We have to take into consideration all these things.
yes, Your Lordship, but my thing is that, Your Lordship, because ultimately it is pension, voluntary pension, it is a honor of the service I have rendered, and I have
That
rendered
purpose,
more
you have
than.
to come within the purview of this rules itself. If the rule says not entitled, you can't get it. If rule says entitled, then certainly you'll get it.
Yes, Your Lordship, by their rules only, 2.1 voluntary service, it is for 15 years is required, Your Lordship.
Madam, then for that purpose, you have to either you stick to one position that you have completed your services were up to 2002 or up to 2016 till you died or age of retirement. Will be deemed to be in service up to which date?
Up to 2002, from the very beginning.
2002, then you have to satisfy us that 2002, man, this was the provision of pensionable, rules under which you are entitled, and that this voluntary cessation clause was not there in the year 2002. You have to satisfy us.
Your Lordship, and from the very beginning, I have been seeking permission of Your Lordship to submit one judgment of the Honorable Supreme Court discussing very meticulously about the provisions of voluntary pension of SBI, Your Lordship.
Yes, ma'am. Anything else?
I have been seeking the permission of your lordship from the very beginning to place this judgment.
Okay. You have placed this judgment earlier on.
Yes, your lordship, because the rules, everything that is governing the VRS scheme of SBI and other banks. That I have seen.
Which is the relevant para?
Your lordship, throughout the judgment, the first
So
para is
we have to
itself.
go through whole judgment.
No, your lordship, I have marked down by red paints from the very first page, your lordship.
And which is the relevant para? You have this marked head notes as important. What is where is the relevant?
I must have in the pages, your lordship.
You
If
have
required, I will, on the next date, I will
almost
place
every
it.
head note you have marked as important. So we have to go through whole judgment.
I will then on the next date, I will place it, your lordship.
This is not the manner of referring to a judgment. Learning concept of the submitted that the appellant has submitted that the learned single judge has come to the conclusion that the stand of the appellant bank that the husband of the petitioner was deemed to be voluntarily retired cannot be considered unless the same is supported by any rules governing the service condition of the employee of the bank. And counsel has submitted that the the recruitment policy of the appellant bank clearly appellant bank consists of a clause 2.7 clause 2.7 wherein it is provided that if an employee voluntarily vacated his employment despite if an employee fails to report on duty despite service of notices upon him or her to explain the unauthorized absence from the service, it would be deemed that he or she has voluntarily vacated his employment. And concept has submitted that the learned single judge has not taken into consideration the above aspect of the matter and has held that the trend of the appellant bank of treating the respondent as voluntarily retired is not acceptable. Learned counsel has further submitted that as per the as per the State Bank of India Employees Pension Fund Regulation 2014, the petitioner, the husband of the respondent is not entitled for any pensionary benefits. Pensionary benefit, full stop. Per contra, learned counsel appearing for the respondent has opposed the submission made on behalf of the appellant and has submitted that the learned single judge has not committed any illegality in directing the appellants to consider the claim of the respondent to release the retirement and pensionary dues applicable to her late husband for the services rendered. Full stop. Having heard the learned counsel for the parties, we deem it appropriate, we are of the view that matter requires consideration, hence admit no need to issue notice to the respondents. Since to the sole respondent, since she is represented through a counsel. In the meantime, expect an operation of the order dated 2/4/2024, part and section number 660/2021 shall remain state list in due course in February 2025.
Obliged. Item 25.
My lord, yesterday we have filed our affidavit in reply. So let it, yesterday, let it come to the record. Service done.
So we have to call for it.
No, I have not called. Let it come next week, my lord. By this time it will. Obliged.
Item 26.
Yes.
My lord, this appeal is pertaining to the settlement of a fishery, my lord. For 7 years, my lord, the NIT was issued in 2019 and 2024, 6 years is almost over, my lord. So, my lord, my humble submission is that initially the petitioner submitted their tender with all valid documents. Comparative statement, page number 55 says that they have not 100% fisherman certificate and we have everything, my lord, including 100% fisherman certificate. That is why a decision was taken in the minutes that I have annexed, my lord, that my tender is found in order, my lord. They have a defective, my lord. It is very clear, my lord. So there is an order, my lord, in favor of me to settle the fishery with me. But thereafter, my lord, the departmental authority issued a notification, my lord, in 2018, my lord, and that, my lord, the question of distance has come. But the question of distance is very much silent in the NIT. So, my lord, it is also not a criteria as per the NIT. So, lordship may kindly come to page number 53 for a moment, my lord. Page number 53. Serial number 2, Tuhsildar is there, my lord. Tuhsildar, in the top line, my lord, in the middle portion, lordship may kindly see N. That is, my lord, 100% fisherman certificate is not there in favor of Tuhsil, my lord. So the petition, appellant before lordship is next, my lord, serial number 3, Somiti Das. In respect of her, my lord, every middle column is yes, my lord. Why, my lord? Every documents are there, my lord. That is why the decision was taken. Lordship may kindly see page number 55. Page number 55, my lord. Middle portion, lordship may kindly see serial number 2 and serial number, my lord, 3. My lord, if we compare, my lord, it comes that serial number 22, Tuhsildar, the 100% fisherman certificate is not found, my lord. And serial number 3, my lord, our documents in order, it is marked in order, last word, my lord, last term. And that is why, my lord, lordship may kindly come page number 55 down below, my lord, last 3-4 lines, my lord. In view of the above, this order has been passed, my lord, in favor of me.
Yes,
My lord, initially, my lord, the petitioner appellant was selected for settlement, my lord. But till now, my lord, it is more than
it was selected and then by whom?
by the lordship. Page number 55,
Tender authority.
my lord. Authority, my lord. Page number 55, my lord.
Then
My lord, we filed the petitioner notice was issued, my lord, and it was finally decided and
in his favor.
favor, my lord.
No, on whose application it was decided? So, how the matter went up to this state government? Why the matter went up to state government?
My lord, the decision was taken by the additional deputy commissioner Fishery Dhemaji, my lord.
Yes,
My lord, the impugn order, my lord, by which, my lord, they have been selected, my lord, page number 61. This order is issued by the Joint Secretary to the Cooperative Society, Assam Fishery Department, my lord. Page number 62, my lord.
yes.
My lord, my humble submission is that, my lord, only 1 year time, my lord, is there, my lord. So, lordship may direct the authority to settle the market 1 year time, my lord,
In your favor.
to operate as, my lord. This is my prayer, my lord. We have waiting for 6 years time. We are very tender, my lord.
That's all.
My lord.
The appellant has approached the writ court by way of filing writ petition number 2422/2020. Being agreed with the action of the respondent number 5. Dated 19/5/2020. Whereby the number 22 Lai Pulia Mean Mahal Fishery was settled in favor of the private respondent number 5.
5.
Respondent number 5. The case of the learned counsel before the case of the appellant before the learned single judge was that the respondent number 5 committee has not furnished 100% actual fisherman certificate issued by the assistant registered cooperative societies in terms of clause 1 of the NIT. Full stop. It is also submitted that the tender evaluation committee has recommended for settling the fishery in question in favor of the appellant, but later on the state government has illegally settled the same in favor of the respondent number 5. The learned single judge, after taking into consideration the facts and circumstances of the case, has come to the conclusion that there is no illegality in the action of the state government in settling the fishery in favor of the respondent number 5, since the respondent number 5 has furnished an certificate issued by the DFDO Demaji verifying that the respondent number 5 is 100% actual fisherman committee. The learned single judge as finally decided the death petition by observing as under para 9 to 14. 9 to 14. The learned concept of the appellant has failed to persuade us to take a contrary view as has been taken by the learned single judge, hence we don't find any merit in this appeal. Thank you.
Item 28.
May I please also? May I please your lordship, my lord? Here in the instant case, my lord, what happened, my lord? A tender was floated on 4/7/2024, my lord, for my lord, erection of line and my lord transformer at Biswanath Sariali, my lord. I, along with two bidders, has participated in the said tender process, my lord. And all three bidders were technically qualified, my lord. And my lord, on my lord, 31/7/2024, minutes of the meeting of technical bid, I was qualified, my lord. Then, my lord, on 2 August 2024, my lord, BOQ summary detail was prepared, my lord. And my lord, as per that BOQ, my lord, I was the lowest bidder, my lord. Then what happened, my lord, I am expecting that that said particular contract work will settle with me, my lord. But subsequently, we came to know that from respondent number 10, who was the highest bidder in the instant tender process, my lord, they are asking for, my lord, price justification. At that point of time, my lord, my lord, appeared before the, I filed this petition before this honorable court, my lord, and the motion state, the honorable court had taken assurance from the, my lord, respondent authority that they shall not issue the work order, my lord. Subsequently, this way has been happened, my lord, and my lord, ultimately, this matter was disposed of, my lord, on, my lord, 3/10/2024, my lord. If lordship, in this case, what happened, my lord? There are, my lord, in respect of price, my lord, the bidder have to fill up two documents, my lord. One is, my lord, form of bid, my lord. This is not part of tender process, my lord. Because, my lord, I say, my lord, if your lordship go to the inner page of the tender document, that document is not available. Its format is also not available. And another is Form 7, which is on, my lord, encrypted form, my lord, and it is computer originated. When you are going to fill up the, my lord, document, item wise that has come, my lord, and subsequently that shall be fill up, my lord. And my lord, what happened? They say subsequently, my lord, that my bid document was not considered because
form of bid, I have stated that the price quoted of bid of quantity is the my price bid. As per 13.1, my lord, of the my lord clause, it was categorically stated that if there is a difference coming, my lord, in respect of my lord, not this difference, my lord, in respect of considering the tender, my lord, clause 1.1, my lord, then my lord, section 7 bid of quantity will prevail. My humble submission before your lordship is that form of bid which document has been, my lord, they have stated it is a redundant document, and their clause, my lord, as per my lord, additional note of 20, my lord, it was categorically stated that document should be decrypted. Thereafter, you fill up the read, and the document should be encrypted. And if your lordship go to their affidavit, they say form of bid, which is section 6, cannot be, it is an unencrypted document. They himself said, and that is the 20 said, if that is so, then his tender is liable to be, my lord, cancelled. Meaning thereby, it is a redundant document, and if this clause has been considered, my lord, the whole tender process shall go, my lord. I am coming one by one, my lord, in this case, my lord, for the, my lord, satisfy, my lord. Your lordship has come to the, my lord, page 81, my lord.
Your form number 6 is there on the record?
Yes, sir.
Where is that?
Yes, sir. Your lordship kindly come to the page 185, sir, no?
One,
No? 178, my lord.
178.
Yes, my lord. One 78. 179 only. 149. Yes, my lord. Form number, because we are facing page 188, my lord. I have stated, sorry, 178, my lord. I have stated the bid quoted in the BOQ is my, the reason behind it. This document is an
We
unencrypted.
offer to execute the work prescribed above remedy so and so below address for sums as quoted in the price.
Yes, my lord.
And 13.2 says,
Yes, my lord. 13.2, my lord. Before going to that, my lord.
so before going to the first come to
No,
this.
my lord, because the concession has been given to the respondent number 10, my lord. If your lordship not reading it conjointly that document, my lord, then, my lord, I want to show, my lord, what is the malified excesses of power for collateral purposes.
First of all, you admit that yes, you have not quoted the price as per clause 13.2.
Yes, my second part I have completed.
Just the bidder must.
I am reading that part, my lord.
Price in the section form bid, both in figures and words.
I'm-
That is not there, na?
And next line, and duly signed by the bidders. He has not signed by the bidders, respondent number 10. If your lordship go to the document, my lord, that concession has been. And second part, I have.
First of all, you come to your case, your bid has wrongly been treated as a non-responsive, then we'll come to his case.
My humble submission before your lordship is there. My humble submission before your lordship is there. When the respondent authority has argued before my lord, learned single judge, they have said that no, duly signed parties we cannot accept. And this is 13.2. They said only facts and figure part will be accepted. They concession given to that particular point 13.2 to respondent number
Sir, you
10.
just, first of all, you satisfy us that
Yes, my lord.
your bid, which
Yes, my
was
lord.
treated as a non-responsive, was wrong. Then we'll come to his case. First of all, you satisfy us that your bid
Yes, my
was
lord.
responsive.
Yes, my lord. I'm coming, my lord.
Otherwise, also others bid was not responsive or whatever it may be. You first satisfy us that
Yes, ma'am.
your bid was illegally
my humble
treated as not
submission before
responsive.
your
Then
lordship.
only will come to his case.
My lord, I could not, my lord, place my case, my lord, properly. My humble submission before your lordship is that, my lord. They have given concession to the respondent number 10. I am reading 13.1 and 13.2, my lord. Thereafter, I will come, my lord. Your lordship kindly bear with 5 minutes, my lord. I shall satisfy your
We
lordship.
are here.
Yes, ma'am.
We are hearing.
Yes, yes, my lord. Yes, yes, my lord. Yes, my lord.
Whatever time.
Yes, my lord. Page 95.
Yes.
The contract shall be for the whole work as described in subclause 1.1 based on the price bill of quantity submitted by the bidders. That is 13.1, my lord. Then your lordship come to the 13.2. The bidder shall fill red price line item total in both and figures what all item that has been done in section 7 document I. All item describe bill of quantity along with total bid rounded nearest rupee item for which no price is entered
Bill paid the special chief engineer, so and so the dating. Next, come, my lord, this line. Lordship, kindly try to satisfy your lordship this point. The bidder must quote his bid by section 6 form of bid, both figure and word, which is duly signed by the bidder. First part, I am not, my lord, completed. Second part, he was not completed. I can satisfy your lordship from that document. I said that rebate has been given to that particular person. Why not, my lord? That is my humble submission before. Because Central Coalfield has said, if your prescribed format has been followed, it is applicable to the all bidders, say paragraph 55, my lord. Not for the single bidder, my lord.
So you are admitting that you have not quoted the price.
I am
that is
quoted,
there.
assuming, my.
His bid is also not complete.
Yes, ma'am. Assuming but not admitting, if they are reading like this, my lord, then, my lord, this thing, this his respondent number bit also go, my lord. Assuming but not admitting. I am submitting, my lord, because this form of 6 is a redundant document. From the very first time I am arguing this for that this document is redundant. Why, my lord? I will come, my lord. Lordship, next line, my lord. A financial bid without any mention of bid price in the bid shall be treated non-expired. I mentioned bid price. What rate of the corporate in section 7, that is my bid price, my lord. Because, my lord, I have and shall not be considered for evaluation. I mentioned the bid price, my lord. Second line, I have, my lord, fulfilled. First line, if they say that I am not completed, he also not completed. You also kindly his document. 181. 184, my lord. Lordship, kindly look to page 184.
Yes.
Page 184, my lord. That is his form of bid, my lord. That so and so we offered to execute the bill of quantity address 10 lakhs 50, which is 2 crore below than the rate price quoted in the bill of quantity. I'm coming because of my this document is unencrypted document, my lord. If document is unencrypted in any tender from my lord, then, my lord, what happened? The rate should be known by all bidder. And as per my clause 2.2, my lord, clause 2.2, my lord, they can modify the bid. And that should be open at the. May I come in, my lord? Its signature.
The query which we are raising, please answer that and then you come to your answer.
Yes, my lord.
Page 184, whose signature is this?
My humble submission, if it was digitally not signed as per additional note 20, page, my lord, 82, 81, 82, 81. Then, my lord, his tender is liable to be rejected. I said so.
His tender, first you come to your case, you satisfy us, then only if we are satisfied that your tender, they have wrongly treated as non-responsive, then where is the question of considering his tender, sir? First of all, you satisfy that your tender has wrongly been treated as a non-responsive. Your case is made out, then it's okay.
I want
to go into his.
I want to submit before your lordship is that the concession has been given to the one tenderer. Now, why not concession has been given to the other tenderer, my lord? If that is so, my lord, suppose tomorrow BFL has made the professor, my lord, and suppose a person MSc, my lord, first class, he has got some, my lord. Then your lordship kindly come to page 184, my lord.
Yes.
That does not digitally sign. Second, dispute review expert was not fill up. 6, and my lord, address was not given, my lord, and not fill up column of review expert, my lord. 4, my lord, incomplete field. Your lordship kindly come to the page 81, my lord, for important, my lord, very important, my lord. Additional note. Online price paper shall not be submitted on paper. Next, my lord, your lordship kindly come to the from D, which has been mentioned on bottom, my lord, just before 2 lines. Additional note clause 18, formal and signing of the bid. All online bid fill up by the bidder has digitally signed as per procedure described in the user guideline. Here, user guideline has been given, my lord. Your lordship kindly go to the page 82.
Okay.
82. Then,
Having heard the letter concept of the parties, that let me deem it appropriate, that matter we are of the view that matter requires consideration and admit. No need to issue notice. Parties are represented. Leave this matter for hearing in due course.
my lord, pay for interim order, otherwise my matter will become. Otherwise, I satisfy your lordship too, my lord. I shall satisfy your lordship. Some point, if your lordship go, if your lordship go to some point, my lord, then your lordship satisfied. Because he's
February 2025, for final hearing in February 2020. Sir,
my lord, otherwise my matter will become infectious, my lord, if the tender is.
come in the February.
Yes, ma'am.
Your lordship, if I may permitted to start, my lordship.
Yeah.
My lordship, the issue involved, one of the issue is challenge to section 16 subsection 4, my lordship. My lordship, as your lordship aware, this amendment, there is a latest retrospective amendment in the Finance Act 2024, which takes care of the allegations in the impugned order, my lordship. With that, once that retrospective amendment is given effect to make present case, the amount will become has to be set aside, my lordship. Apart from this, there is another portion of the demand, my lordship. My submission to that count is, my lordship, the impugned order was passed without affording the personal hearing, my lordship. My humble submission before your lordship is that the matter may go back for re-adjudication of the case in light of the retrospective amendment, as well as after giving a opportunity of being heard to me, so that the demand can be effectively adjudicated.
Opportunity of hearing in relation to what, which point?
Mainly, my lordship, there are mainly 2 demands, my lordship, out of the total demand. One demand is denial of input tax credit under the being a time bar under section 6.
That would be taken care by this subsection 5 of
Yes.
16.
Yes, my lord, subsection 5, my lordship.
Yes.
Then what remains is another major demand is the differences between the ITC claimed in GSR 3B versus GSR 2A, my lordship. There again, my submission is that there is the difference what was arrived in the impugned order is not correct. There is some different amount is the difference amount. And out of that, majority of the amount I have already reversed during the assessment itself, which was not considered by the impugned order because they have not given me the opportunity of being heard. Once that opportunity is given, I would place all the records so that can be verified and later the order can be passed, my lordship.
Where is the impugned order?
My lordship, it is at lordship, page number 90 is the impugned order, my lordship.
90.
90, my. 90 is summary of the order, my lord. 91 and 92.
Notice. It's a show cause notice. Order, show cause notice under section 73.
Yes, my lordship. Show cause notice is before that, my lordship.
Okay.
Show cause notice is page number 74, my lordship.
GST.
Yes.
My lordship, my lordship, if I say this, my lordship, 75 subsection 4 is the my lordship, which provides that opportunity of being heard shall be given either when it was being asked in writing or when adverse order is contemplated against the taxpayer, my lordship. Subsection 4 of section 75 of CGST Act, my lordship. My lordship, if the permission may I read, my lordship.
This, who is appealing for the last time on, this, one occasion we asked you to ascertain whether the opportunity of reading was provided.
No, my lord, in fact, I got the instruction, my lord, I've furnished two sets, my lord, of the instruction. Last para says that, my lord, they are ready if the matter is now remanded back, and they will consider it, my lord, afresh, in view of the new provisions of, my lord, subsection 5 and 6 of section 16 of the CGST. Lordship will see the last page, in the second page, last two paragraphs of my instruction dated 19th of November 2024.
Yes.
The last second para and
Read.
in the 54th GST Council meeting, it is recommended as section 118 and 150 of the Finance Act 2024, which provides for insertion of subsection 5 and subsection 6 in the section 16 of the CGST Act 2017 retrospectively, with effect from 1/7/2017. The council also recommended that a special procedure for rectification of orders may be notified under section 148 of the CGST Act to be followed by the class of taxable persons against whom any order under section 73 or section 74 or section 107 or section 108 of the CGST Act has been issued, confirming demand for wrong availment of input tax credit on account of contravention of provisions of subsection 4 of section 16 of the CGST Act, but where such input tax credit is now available as per provisions of the subsection 5 or subsection 6 of the section 16 of the CGST Act, and where appeal against the said order has not been filed. The council also recommended issuance of a circular to clarify the procedure and various issues related to implementation of the said provisions of subsection 5 and subsection 6 of the Section 16 of the CGST Act 2017. The notification has already been notified by the CGST. Therefore, if the Honorable Court finds it necessary to give an opportunity to the petitioner to present the case before the concerned authority, the Honorable Court can remand the case to the jurisdictional officer with a direction to relook the entire matter as per provision of the Act, and also with a direction the petitioner to cooperate with the proceeding under Section 73 of the GST Act in order to bring the process to a logical end. And my lord, that circular has also been issued, my lord. I have furnished a copy. It is of 15th of October 2024. It has been issued by the central government. In the last page, my lord, para 5 probably will cover, my lord. The clarification is given. The petitioners are aware of this now, my lord. They can avail the benefit now. And considering the recent development of amendment.
Then for that reason, we have to set aside the order.
Lordship may set aside and give the liberty to my lord, consider it afresh. Giving due opportunity to the petitioner.
This petition is prepared on behalf of the petitioner.
Yes, ma'am.
Essentially challenging the.
Okay, what do you think?
The validity of section 16(4) of the CGST Act 2017. And 2007, CGST Act 2017. The petitioner has also prayed for washing and setting aside the order dated 31st of March 2023, whereby time limit was extended for passing the orders. This 31st of March 2023 is order dated.
My lord,
This order dated 31st of March 2023 notification, sorry.
it is notification.
Where is that notification?
My lordship, it is at 178, my lordship, page number 178.
178. 178. Where is that one?
Comes in the almost last, my lordship, in the end. 178.
It's 82. Can you check? The notification dated 31st of March 2023 issued by the Ministry of Finance, whereby the time was extended, a time limit was extended for passing the orders under section 73 of the CGST Act. Full stop. The petitioner has also challenged, has also prayed for washing and setting aside of the order dated 28/1/2024 issued by the respondent number 4 under the provisions of CGST Act. Full stop. It is submitted by the learned counsel for the petitioner that with the insertion of subsection 5 of the subsection 5 in section 16 of the CGST Act by way of finance bill.
Yes.
Finance Act to 2020.
Finance Act 2000.
24.
24, my lord.
The grievance of the petitioner regarding availing the input credit tax. What is this?
Tax credit.
Yes, my
Ah,
lord. Input tax,
ITC,
input tax credit.
tax
Input
credit.
tax credit is more or less resolved. However, it is submitted that the impugned order in respect of certain other demands have been passed without providing any opportunity of hearing. So if this court deems it appropriate to then the matter may be remitted back to the authority concerned for deciding the claim of the petitioner afresh after providing him opportunity of hearing to it in accordance with the provisions of the CGST Act. Full stop. Learned counsel appearing for the revenue, Mr. Gogoi, has also submitted that he is already in receipt of instructions from the department that the matter may be remitted back to the authority concerned for deciding the issue afresh in accordance with the provisions of the CGST Act, including the new amendment introduced in section 16(5). Full stop. In view of the above submissions made by the learned counsel for the parties, the impugned order dated 28 1/2024 passed by the respondent number 4 is set aside. The matter is remitted to the respondent number 5. Respondent number 4 to decide the matter afresh in accordance with the provisions of section 16 of the CGST Act as amended after providing opportunity of hearing to the petitioner expeditiously within a period of 2 months from the date of production of certified copy of this order. The
Lordship, only one request, my lord. Other issues also may be considered, my lordship. Other issues may not be directly related.
the other issues will be considered. What do you think? After providing an opportunity of hearing, you are free to raise whatever the issues are available. With these observations, the petition is disposed of.
Deeply obliged.
Item 30.
My lord, still, my lord, Honorable Apex Court, my dear please.
No, most probably, one of the co-accused, he has applied last week, most probably.
Most probably.
That's what I've been told.
Then we'll wait for that.
Yes, but-
Now the situation is somewhat.
Yeah, it has become more.
May.
Maybe, yes.
January.
Yes, after vacation.
January. Yes.
Item 34 to 37.
So it's still pending on 7th January, it will be listed, lordship.
Your lordship, if your lordship may want to hear, then maybe taken up after some time.
Second week of January. Third week of January.
Lordship. Oblige, your lordship.
Supplementary list for admission, item 60, along with item 1 of production list.
Lordship. Lordship may have please first the IA, which was, the notice was issued, Your Lordship, after filing of the writ appeal. The same notice, Your Lordship. And the honorable single judge has.
Just a minute, ma'am, please.
Ma'am.
Yes.
Madam, Your Lordship, the IA has been filed because the notices, the undertaking has been, time of undertaking has been granted up to 10th November 2024, Your Lordship, and the order was passed on 30th. Thereafter, the Deepavali vacation and Chhat Puja. The petitioners have given the request of undertaking on 6/11/2024, Your Lordship. There was no response from their side, and they had seized the shop of the petitioners, Your Lordship.
Actually, the court order was there.
Your Lordship,
The court order was there up to 10/11 if you are not supposed to file.
Your Lordship, up to 27th, the Supreme Court has already given the time of 2 weeks for the.
What is the order of the learned single judge?
Yes, Your Lordship. That was challenged. That is challenged before Your
It is
Lordship.
challenge, we don't find any ground for challenge.
No, Your Lordship, I have. Because the.
But
No, Your Lordship,
this
because.
is for the court to see the ground.
Your Lordship,
You
yes.
may have the grounds.
Yes, Your Lordship, kindly.
Your grounds are not sufficient.
On the basis of Messrs. Deepak Company, Your Lordship, the matter has been rejected. And that was related to the tender proceeding, not from the agreement, Your Lordship. And that was later on of 2014, Your Lordship, only for 5 years. But here the petitioners are petty petitioners and they are, since Your Lordship,
Is there any provision under the, this policy of 2017 for extension?
They are, your lordship, they have given, your lordship, for a moment, they have given affidavit before the concerned that they have got only one stall. And they are governed by the circular number 22, 2017. That's why they will be covered under 618, 620, your lordship.
That has already been considered by the court and rejected their
No,
claim.
your lordship, it was wrongly rejected because,
Wrongly rejected, then challenge it.
your lordship, before you,
No.
your lordship,
Earlier, when the court has categorically held that.
your lordship, I have,
2017,
I
there
have,
is no policy,
no,
there is no provision for extension
Because-
of this.
because-
license. It can't be
because the prayer,
extended.
your lordship, the prayer of the petitioner was for quashing of the notice, because the notice was only for 10 days. And on the basis of the earlier order, your lordship, 23rd for 2024.
Yes.
And that was for the depositing of the license fees after the respondent will provide the license fees. But they did not provide, they only provided on 30th.
What happened to that challenge 23rd of January 2024? What was the fate of that order?
Yes, your lordship, kindly have,
Yes.
your lordship.
Lordship, can this matter may be taken up to some time because Mr. Gupta is on legs, my lord.
We have only this matter and no matter
My lord.
is there. Other
This
matter
matter is covered by my lord.
We have only this matter, no
my
other
lord.
matter is.
My lord.
Yes, your lordship, kindly have. Your lordship, the relevant part, page number 44, it begins with page 44. And 142, the date of the order, 23rd for 2024.
Read
Yes, your lordship.
page 44,
44, 144.
144.
Well, the counsel for the parties submit that while the issue raised in 3 writ petitions regarding catering policy, it is not applicable, it has been contended by the respondent. Para 7, your lordship. It has also been mentioned, submitted at the bar that some of the members of Petitioners Association 1131/2012 have expired in meantime. Arising out this, your lordship, this order has been passed. On considering submission made by the counsel for the parties, keeping in view that new catering policy has replaced earlier 2000, beside the fact that the contract agreement between the parties have expired way back, the present writ petition are being disposed of by term of paragraph 22 of the judgment and order dated 29/2022 in writ petition number 6, which is as follows. Taking in consideration that by dint of the interim orders, the petitioners are still paying license fee at the existing rate fixed in the year 2000. The railway authorities would be at liberty to enhance, reassess the license fee of the petitioners notionally every 3 years on the basis of actual sales turnover of the writ in the matter of to be done in terms of clause 18.3 and 16.23, 2.3 for the period with effect from 1st November 2010 till the date of the instant judgment, and to claim such enhanced amount and areas thereof in terms with such assessment. It is clarified that if materials data are not available, then the railway authorities would be entitled for minimum enhancement of 10% every 3 years since 1st November 2020. Further to that, the respondent authority shall also be at liberty to take such steps as envisaged under the law as per its present existing policy in respect to the vending units of the petitioners. The last part they have applied, but before that they didn't pay any assessment fees. Last time when they issued the notice, they have given, your lordship, on only unilateral time, a short time, 7 days they have given. They had not given more time, your lordship. If they had to give, your lordship, there was no problem. And your lordship, my
The
humble,
court has already extended that time.
no, your lordship, court has not extended that time. I have given that time, your lordship, just now, yesterday I have filed and they have served the notice on 14th. Again, they have served the notice. And before this, your lordship, they have closed, they have seized. While there was no such, only 27th, up to 27th, your lordship, it has been given. Kindly have. And
Read the order.
yes, your lordship. Your Lordship, page 23.
Yes.
Already there are the Lambding Association has got the stay order from the Supreme Court in the identical and same petty contractors.
That learned single judge has taken into
No,
consideration.
if your Lordship may permit, may I read? The dismissal of review petition 117 by 2023 by division bench of this court was then again put to challenge SLP 7501 to 52. The Honorable Supreme Court in SLP was the view that when the earlier SLP has been withdrawn without liberty being taken to file the same afresh, a fresh SLP could not have been filed. However, as there was a contradictory order passed by a bench of equal strength of the Honorable Supreme Court in another case, the said issue was referred to a larger bench of the Supreme Court for a decision. It was in the context that Honorable Supreme Court had directed that the members of those associations should not be dislodged from the places under their occupation till the next date, Your Lordship. I have brought the order, Your Lordship. Your Lordship may please.
My lord, in respect of the shops, already new tender has been issued.
That is in respect of this Lumding Bazaar.
Association, Your Lordship.
So-
They are the petty contractors, like the petitioners, Your Lordship.
Whatever it may be,
Your Lordship kindly have,
your case has already been decided. by this
Your
court,
Lordship,
then
for a moment,
we can-
Your Lordship.
Where is
Because Your Lordship, there
There is
is
that order of 23/1/2024
23/1/2024.
and the subsequent order passed by the division bench.
In Mrs. Deepak, Your Lordship, not in the present case. Your Lordship, I have brought the order of the Mrs. Deepak. That is different, Your Lordship. I have also brought the record because that was the commercial bid and they are the petty contractors, your lordship. Kindly have their original license, your lordship. And it will govern by your lordship. Your lordship, it will be governed by the judgment of Supreme Court, your lordship, for the civil appeal number 618.
It's not a judgment, it's an order simply.
No, your lordship, it will applicable on the petitioners. Your lordship, kindly observe this para, your lordship, for a moment. Para number 2. Because they have given the affidavit before the concerned authorities that they have got only one shop, kiosk. Therefore, they will not be covered by 2017, your lordship. It is my argument and it was not considered. And there was no compare with the Messrs. Deepak Company, because Deepak Company is millionaire company, your lordship. And at every railway stations, they have got their shops. And they are the petty contractors. They have from 1940, your lordship, and 1950. And they have no business except this one, your lordship. Their third generation is going with this, your lordship. Where they will go? Merely on the basis of this. This is the agreement, your lordship. It is to set earlier. तो भी दिया गया था उसका basis. This is your lordship judgment in Messrs. Deepak Company case, which is totally different to the present petitioners. Their bid is the commercial bid and pure contractual, your lordship. And the petitioners have been given several times facilities from the railway since 1940, 1950 and 1990. And still, your lordship, if they had paid asked the license fees, what was the crux of the order? dated 23rd April 2024, your lordship. It will never happen, but they didn't ask any and they only straightforward given the notice and give a short time, your lordship. Neither they have given opportunity of hearing nor asking any reply. Whether you have complied, they have to comply, but they did not comply. In spite of that, your lordship, they have given and closure notice immediately with a short period. If the person is doing from such long time, at least your lordship, 1 month time will be given to them to settle themselves. The order for Mrs. Deepak was challenged, your lordship, before this honorable single judge and thereafter troubled before your lordship. That especially they have stated that your original license for only for 5 years. And there is no such for us, your lordship.
This, Mr. Where is the judgment wherein this court has held that this policy of the 2010 would be applicable and not 2000, this 2017 would be applicable and not 2000. Where is that judgment?
And this judgment was, my lord, challenged before the apex court, my lord, SLP was dismissed.
150. 150. Your Lordship, may permit, I want to bring the order of the Messrs. Deepak Company, especially there it has been written that these are the fresh vendors.
So when the licenses were issued to you,
Your Lordship, in the year 1940, 1950, 19.
best,
Next, Your Lordship, in the year 2011.
thereafter,
Thereafter, it was continued, Your Lordship. It has been continued
2011 up to which date?
for, Your Lordship, I have supplied the copy to Your Lordship.
Your license was renewed last time when?
It was renewed, Your Lordship, in the petition number 1131.
Madam, date पूछ रहे हैं, we are asking a date when your license was renewed last time.
It was renewed up to Your Lordship 2024. Month is not confirmed, Your Lordship.
2024?
24, Your Lordship. Because
2024 is going on now.
yes, Your Lordship, but
Yes.
the month is not clear. As
Okay,
per the,
fine. Up to December 2024 we deem.
yes, Your Lordship.
So now December 2024, after that you have to vacate the premises.
Your Lordship, but till then some time, because they have
What
closed.
time? Time has already been granted,
No, no, they-
27/12/2024.
Yes, Your Lordship.
That's all.
Till then, we have to clear the license fees.
You have to clear the license.
Yes, Your
fees.
Lordship.
Up to 10/11/2024, you have not.
10,
cleared it.
11, Your Lordship, according to Supreme Court, Your Lordship, 27th December 2024 has been given, Your Lordship. Not up to, and there was no time was fixed, only 2 weeks of the undertaking, Your Lordship. That was given there. So we have got
What is
the,
the Supreme Court order?
yes, Your Lordship. Oops. Yes, Your Lordship.
Yes.
My lord,
So the learned single judge has said that you give the undertaking
my lord, I have given,
by 10/11/2024 that we will vacate the shops by 27/12/2024 and pay all the dues.
yes, your lordship,
Have you furnished that undertaking?
yes, your lordship. On
Where is that?
that is with IA.
IA.
Yes, your
Where is that IA? Where is that undertaking?
Yes, your lordship. Page number 10.
Read.
Prayer for extension of undertaking of units at Mariani Station, Farketing on the
Where is
subject.
the, what is the jurisdiction with them to extend the time of giving undertaking? That time was fixed by the High Court.
My lord,
What is the authority of this officer to extend that actually the time?
we have given for consideration for 10 days, your lordship time.
How can it be, even though if you have given for that, what is the authority of this officer to extend the time which is fixed by the High Court?
But they have given the reply on page 13, your lordship.
Yeah, read.
On the WhatsApp message, payment clear receipt, your lordship,
Where is that?
page 13.
Read what they have said.
Payment clear receipts. Undertaking to be given that stall will be vacated on before 27/12/2014.
Page number 14,
No, 13,
13.
13.
To whom so it concern?
No, that's the what.
DCM, senior DCM.
This is to certify that.
No, this is the medical, this is not below, your lordship.
Undertaking to be given that store shall be vacated by so and so and no third party.
Party.
To deal without.
Payment clear receipts. It was given by the senior DCM on WhatsApp message, your lordship. And thereafter, your lordship, they have gone before the authorities on 11th because 10th was the Sunday and
What is the
because of
date?
the Chhath
Date-
Puja.
Date kya hai iske andar? What is the date of this communication of what's it?
6,
6/4.
they have not mentioned, but it was for the 6th. Because after Chhath Puja, when they returned, they went before them, but they said ki black and white. Come with black and white, likhit mein aiye. So they have gone on 11th, your lordship. Only on one day, your lordship.
Where is that 11th undertaking?
It is on mobile, my mobile phone, your lordship. They have sent to me, it is on mobile phone. It is not,
Mobile
but
phone
I
is
have
in your
mentioned,
Mobile phone.
no, I have mentioned in the para,
Frame it, get it framed.
I have mentioned in the para, your lordship. Your lordship kindly have. Note, para 7.
Yeah.
Internal basis, that it is important to invite the attention of this honorable court that only after one day of delay in undertaking, the railway respondent had sealed the stalls of the applicant.
Where is your undertaking?
Simply they could have given the undertaking.
If your lordship may permit, just now after 30 minutes, I can provide it because they have sent to me.
Please, now.
Your
don't
lordship,
waste your time.
there is
Okay,
only,
so you'll now prepare a undertaking and then submit.
no,
it
no,
before
your
us?
lordship,
Or
not
what is-
prepare, your lordship, it is here. If your lordship may permit, I can show. before
No,
your
will
lordship.
not come.
Your lordship, there is only request, my humble
madam.
request.
We
Your
can't-
lordship for a moment,
No,
only humble request.
it would have been there. You should
No,
have.
no, your
attached the
lordship.
Petition itself.
It is with me, your lordship.
It is with you, then keep it with you.
If your lordship may permit. Otherwise, due to the negligence of myself, your
This
lordship.
will not allow.
Your lordship, I have mentioned in the
Court
para.
has granted you 10 days time to file an undertaking.
My lord.
On 6th, you moved an application, since I am busy in Chhath Puja, therefore I will not be able to furnish this undertaking. What
And
is this?
11th,
You are free to approach the authority concerned with the prayer of extension of time, but you can't give the undertaking. This is absolutely just to
no, your lordship for a moment.
avoid the order of this court.
Only my humble submission is this.
Yes.
My humble submission is this, that till 27th, no, till 25th, your lordship, we will vacate. I am taking undertaking, but we have to clear this.
Your undertaking will not do, ma'am.
Because
Undertaking is required from the vendors.
No,
And they have
because-
not furnished any undertaking despite the clear direction by this
They have,
court, then there is
your
no
lordship, they have,
illegality in the action of the
your lordship,
railway
they,
authorities
your
to
lordship,
get your, this premises sealed.
no, your lordship, they have furnished. It is in the record of the railway.
Where is that? Record of the railway, where
Yes,
is
your
that?
lordship,
You have not
because-
even mentioned in your application that you have given such undertaking.
Yes, your lordship. 1 day delay I have mentioned.
Where is that, ma'am?
Your
You
lordship,
just
kind,
mention it. Where is that? That
kindly-
you have submitted the undertaking on 11th and they have not taken into
para,
consideration.
para number 7, 1 day
Read-
delay.
Read
Ah,
para number 7.
that it is important, you have to send this, that only after 1 day of delay in undertaking, the railway respondent had sealed the stalls of the
Where is
appellant.
the specific assertion that though by 10th you have not been able to furnish the undertaking, but on 11th you have furnished the undertaking. Where is that averment?
Yes, your lordship. Para 10,
Read.
order dated 30/10/2000 is granting the time for running stock for clearing all their dues, rents, thereafter vacation, but the same was disturbed by the railway authorities without considering the letter of request dated 6/11/2024 and undertaking dated 11/11/2024.
Where is that undertaking? And where is the specific mention that you have submitted the undertaking not on 10th, by not 10th, but on 11th? Where is that? You are trying to confuse the situation.
No,
Yeah, this is what not.
your
No, we are
lordship,
not
for a moment.
permitting this.
Have it tomorrow, your lordship.
Oh,
Just
for
now, your
what?
lordship, it is only for the print.
Tomorrow, and the same order will be filed. Nothing.
Your lordship, my humble request only for,
Yeah, there is a misplaced sympathy.
no,
We are
there
not
is no,
supposed to
because
extend
your
our
lordship,
sympathies every time in these matters.
your lordship, I need your lordship's observation with regard to this, that 27th, it has been given by your lordship
We are not
also.
supposed to give any observation. We have to consider whether the judgment of the learned single judge is right or wrong. That's all. This is what our jurisdiction is.
But so far the clearance of the dues,
Yes.
if they will not, your lordship, they will not open the shop of the petitioners till, how can they clear the rent?
Yes,
Your lordship, this is the problem.
that's right.
Your lordship may permit only 30 minutes I need. your
Tomorrow,
lordship.
we have already fixed, you have asked for that. We have fixed this tomorrow.
At 10 AM, your lordship.
Ma'am, at 9, we'll come here and.
Sorry, your lordship. Sorry.
What is this? Then when the number comes, we will take the matter. What is the urgency in this matter?
Urgency because
Urgency, your premises were sealed way back on 11th.
11th, your lordship.
And today
11th,
is-
not 11th, 12th, and thereafter,
12th, then today is.
thereafter they have dispatched the notice. From where they are on fault, your lordship, it should also be
We'll
observed.
consider it tomorrow, yes.
Item 61.
May I please, Your Worship?
What more indulgence should we require from the court, sir?
My lord, I am,
What more indulgence?
there is some way out. I think there is some
What is
way.
the way out, sir?
My lord,
How to
The,
improve your vision?
my lord, for visually impaired, the Medical Council of India has its own guidelines. That has not been adhered to. The guidelines, Your Lordship, page
Sir,
290.
you asked for that they have not examined properly. The court has asked the aims, then you objected to that. Then they again asked this Guwahati Medical College, again the same report came. The person, doctor called here and was taken,
No.
was interrogated, or you can say inputs were given by her. And she said, "Yeah, no, it is not possible." What remains then?
No, my lord, there remains, my lord, because there have not been consistent reports, my lords. Earlier reports, no,
There
let,
is a consistent report that this what to say is disability is there and it can't be cured. That is there.
with advance aid. It cannot be lowered. It cannot be lowered even by applying, my lord, advance aid. That is what has not been done in the entire case, my lord. That is my case precisely. I'll show. Page 292, it will similar page to copy letter. But the things went slightly less there with me kindly. My lord. This 19-year-old appellant, she successfully passed NEET UG. She was given a disability certificate by GMCH. Acting on that, the joint director allotted a seat to her. So that is one thing. Whether the question first will be whether there were subsequent verifications necessary after this. Allotted a seat at Diffu Medical College against PWD quota, means physical quota, my lord. However, my lord, her admission was cancelled by treating her disqualified on an alleged report by the medical board. I'm saying it as an alleged report. Why? It has not been as per the guidelines of the MCI, my lord. Now, what the guidelines say, this first report would have been sufficient. It materialized, it was acted upon, my lord. Then, my lord, GMCA issued a certificate. And kindly have a look at page 291, my lord, the MCI guidelines. It starts at page 291. This, everyone ignored this. Page 291, it starts, my lord. It was of 2019. Lords, when I come to the next page, page 292. Guidelines regarding admission of students with specified disabilities under the Rights of Person with Disabilities Act 2015 with respect to admission in MBBS course. Below, my lord. Below in the box, last sentence. Person with visual impairment, visual disability of more than 40%. Kindly note the words, my lord, more than 40%. 40% is the benchmark. It has to be more than 40%. That is where also the single judge aired and everybody aired. More than 40% may be made eligible to pursue MBBS course and may be given reservation, subject to the condition that the visual disability is brought to a level of less than the benchmark of 40% with advanced low vision aids. Next page, my lord, such as microscope, magnifier, etc.
Telescope, microscope, magnifier,
etc. So, my lord, kindly come to the report now, my lord, the latest one, at page 349. This is the re-examination of the medical board. Here, my lord, kindly find, without glass correction, 350. It was 4/11/24.
Yes.
Forwarding. Then 351, my lord, is the report. Re-examined by medical board on 4/11. This was as per court's order, the first case. My writ appeal is against the second case, my lord. Without glass correction, her visual impairment 40%. So it is not more than 40%. Now, upper readings, right at visual, what is called? 6 by 36 and left eye 6 by 60. Compared to the last two verifications, here it has been found to be high. In any case, the distance vision is there. Now, nowhere it has said that therefore you are disqualified or you are required to be disqualified because the report is like that. And moreover, one more thing.
Who's going to say that you are disqualified?
Because seat was cancelled.
No, in this report, how they can say that she is disqualified? They have simply, what they have examined, they have reported it.
No, page 95. Page 95. However, subsequently admission was disqualified. Yes, page 95.
Yes,
After initially I got this subsequent to my initial allotment at DIFU, this was a admission notice finally given where my roll number is not there.
Yes.
That's why I'm saying, and my allotment of seat is also there in page. First,
That was subject to the verification.
no, I was allotted with the seat that was said on the basis of a certificate given by the GMCS.
94.
Right, in any case.
94 does.
Yeah.
Paragraph 11. 229 of
220. First order, no? Decision not to proceed. Then coming to the report, Lordship.
Sir, that whatever the certificate you were possessing at that time, that was only for the purpose of admission. But after your selection or allotment of the seat, you were subject to go for a medical verification.
Even for that, even by this,
On 22nd of August 2024, therefore you appeared before the medical board.
agreeing to your Lordship, even then, agreeing to your Lordship, even then, this report cannot entail, my Lord, because this report has not been done by applying, my Lord, advanced medical, advanced missionary.
That's why only the matter was referred to the AIMS Guwahati.
AIMS Guwahati by some.
AIMS Guwahati to be qualified.
Not qualified.
No, 40%. It was, my Lord, 6 by 40. AIMS Guwahati said, my Lord, kindly have.
Less than 40.
Yes, AIMS Guwahati said.
AIMS Guwahati did not apply advance aid.
AIMS Guwahati also did not apply advance aid.
This was your allegation.
AIMS Guwahati was.
Then the matter was again referred to the medical college.
Page 210, AIMS Guwahati findings, my Lord, found 40% benchmark disability with 6 by 24 and 6 by 36. Here, 6 by 60. Kindly have a look at page 210. Kindly have a look at. No, my Lord, the whole question is whether any effort was made by them to ensure that my disability can be lowered by allowing me use magnified glass or, my Lord, microscopic lens. No one did that. That is precisely my case. Page 210. Na? खाली लिखे ऐसे लोगों ने 207 नहीं 220 220 222 equity level. Judgment to let it. Photocopy date, no? Belaga Twitter. Bottom two. No, I know it too.
Mr. Kukul, well, you have rejected that case basing on some 40%.
Yes, ma'am.
That
basis for arriving.
Yes, well, that we have annexed, my lord, the report that was furnished to us. No, there is a chart. It is there in our affidavit. Lordship may kindly have a look at. Affidavit starts at page 131. And Lordship will find it, my lord. Lordship will find the chart at page 169. 169 is a part of the affidavit, continuation in the, my lord, writ appeal, memo of appeal. The name of the petitioner appears at page 170, serial number 63. Lordship will see at page 169 at the top.
So you don't have a reservation for usually.
No, my lord, as per this H1, H1 notification or that guideline that has been provided by the Medical Council of India at that point of time, we have to follow that, my lord. Yes. The one that has been just now placed by.
Yes, H1.
In your, my lord. H1, yes.
Yes.
Lordship will find that at page.
That will be gazette notification, my lord.
179. Relevant will be, my lord, page 184. Page 184. Just now it was placed, my lord, in.
I placed it, my lord, 291, it is same. 291, 292, it is the same. 290, it is the same. So, Ames report কিমান আছিলে 168 না Ames code 220 Wait, no. An Ames report which varies is at page 220 to 23. Ames. Thirtieth of October, Ames report. Fourth of the- Equity. সেদিনা নেই এই জন্য আমার নাম মানে কিন্তু লোয়ার বলি ভিডিওটা সত্যি লোয়ার মানে হ্যাপি ভিডিও কেমন এটা এই কথা ভাই লাইন advance it like it is very old William তুই সবার শুনতে পারি নেই ওই জন্য মুভি দেখুন না লেন তো এইমস Wait. Ames report is slightly at variance. And this it was just 4 days ago. I mean, the parameters are changing within 3 days. Medical board on 4th of November, it is on 31st of October. My lord, page 222, 222. Lordship, kindly see.
223.
222 is dated 30th of October. Just 4 days ago, the medical board. Come to the next page, 223. Serial number 7. So and so, both high so and so, 40%. Here also it is 40% benchmark, visual. But here, my lord, the equity is shown at 6/36 and 6/24. Equity.
So how makes a difference?
My lord, equity makes a difference. My lord, there is a chart in the equity, my lord, these are technical matters. Even then, whatever I had understood, my lord, there is a chart showing, yes, these are the equities, lordship. I don't have, they are. In petition, my lord, it is black and white. To decide. This is, my lord, Government of India's, my lord, parameters, guidelines, yellow and
yes.
Here, top, my lord, these are all equities. Lordship, kindly see, when it is 6/24, my disability is less. When it is 6/60, my disability is more. It comes down to 40%. It is a very important parameter. So in the medical board, they found it to be 6/60 straightway. 6/60. And the Ames found it to be 6/36 and 6/24. As a layman, I am saying, having the minimum understanding of these yellow marks and other marks. But one more thing, serious thing.
Either report, the conclusion is
But no, but what the attitude of the government and the medical council is that, see, if this can be lowered by applying aids.
up to the medical that
Right.
If it is above 40%, and then the use of some corrective or below 40%, then you will be entitled
Not
a reservation.
No, disability above 40%.
Above 40%.
My disability is benchmark 40%, not 41%.
Equal to or more than.
Equal to or more than 40% disability. This is the language. Yes, my lord. Yes. Let me. Persons with visual impairment, visual disability of more than 40% may be made eligible and may be given reservation subject to the condition that the visual disability is brought to a level of less than the benchmark 40 with advanced low vision. My lord, the intention of the legislature and the medical council was always to give a chance. See, if it can be lowered, and the Supreme Court also has said so. I'll just read one paragraph of the Supreme Court decision, my lord, that it is not your scales. It is something else.
Not your skills, something else than what?
Something else means your effort to see if it can be reduced. My lord, I am reading one paragraph of this.
Now, what more efforts you want? The court has.
I am coming to that.
3 medical expert opinion.
I am coming to that. And one.
Now, what remains that despite that,
No.
ignoring all this, the court may pass an order.
No, not three medical,
After all, it's a medical court, sir,
my lord.
not a
There,
very
there were,
simple
there,
court.
there were three expert verification.
Yes,
First one was by the GMCA
and
itself.
as pointed out by my brother, all says 40%.
Second one was,
And you want that, don't believe it. And what the petitioner
No.
is saying, we believe this, say, no, that's.
I'm not saying that I am not 40% or 39, I am 39%. Yes, I am 40%, even then.
Yes.
Kindly have a look at this judgment. The attitude is something different, my lord. That's why I am. This is my lord. Did I? Copy this. Have a look at paragraph. Have a look at paragraph 7. This court is of opinion that these reports only quantitatively assessed or evaluate the petitioner's extent of disability. In both the cases, detailed evaluation side from the quantification of the disability is not reflected in the reports. In other words, the reports are bereft of any reasoning which impel the experts to say that these candidates are not capable of pursuing medical course and how the impairments they suffer from would impede or prevent them from effectively pursuing the course which they wish to study in. Here also they have not given any reason. Although the court is cautious that some of the conditions such as deformity and webbook neck are not usual or usually understood disabilities, yet in the absence of any elaboration or reasoning, one is left wondering why these candidates who have been fairly capable of pursuing rigorous academic courses and even reaching a certain level of attainment would be unable to do so in the opinion of such experts. The same logic applies in a case of so-and-so under the Disabilities Act. Then there is another case, my lord.
This is the final order.
Even then I am showing.
This is the final order. While observing this, the court has said the National Commission and central government are directed to consider the problem and work out suitable solution and enable effective participation. This is what.
That is all right.
Ultimately, where are the direction of the court?
I'm showing the observations made in paragraph 7, the attitude.
These are the observations.
And then now I am coming to my case also. Another case, my lord Unkarmal, here paragraph 48. This is relating to medical admission. Page 36.
Yes.
Is 36, 48. No? Page 48, paragraph 48. Page 36. While interpreting regulations, guidelines as provided appendix H1 to notification dated so-and-so as they stood for academic year 24-25. We are constrained, keeping in mind this salutary object of the RPWD Act and Article 41 of Directive Principles to direct that mere existence of benchmark liability of 40% or above or such other prescribed percentages will not disqualify a candidate from being eligible for the course applied for. The disability assessment boards assessing candidates should positively record whether the disability of the candidate will or will not come in the way of candidate pursuing course in examination. There is no such report or no such recommendation in my case on their records and in the pleadings. The disability assessment board should state reasons in the event of disability assessment board concluding that candidate is not eligible. Mere furnishing of a report doesn't do. Get it up. First judgment of Proceed. First judgment, bottom judgment of the decision to Proceed. No single judge.
Yes, 220.
My lord, even the learned single judge in the first case categorically said, that in the event you decide this way, it is all right. If you decide against me, give reason. Give reason. That has not been done. And moreover, it is not simply, my lord, the measuring the parameters on a day, the probability of reducing disability by applying advance aid, which has not been done in my case.
Yes.
Which has not been done in my case. So these are the implications of the guidelines that go work as much as possible to accommodate the child. See, if it will be reduced, that effort was not given. Question is not me trusting AIMS, or I cannot distrust, or this ophthalmologist head of the department. I trust them, but they have measured me by not providing the advanced aid of microscopic lens or magnifying glasses. Give me one chance. I'll go to the same authority. And if your lordship says, all right, give her the advance aid, then furnish a report. I'm agreeable.
My lord, regarding that Honorable Supreme Court judgment, my lord, the difference is, my lord, there the petitioner, he was declared to be not fit for the medical course exam. In the present case, my lord, we have stated that she is not eligible for the PWD quota. We have stated in our affidavit that she is eligible, otherwise any quota or another open category, but not under disability quota because of this appendix H1. But my lord, in Honorable Supreme Court's case, my lord, it was declared in para 6, lordship will kindly note it, and lordship will find it that there is a specific statement recorded that the disability assessment board found him to be not fit for the medical course. On that ground, the Honorable Court said that you cannot deprive a person in this manner. So there is a
we have
vital
not been
difference.
said so. They have
Just I am
told me
placing the
that.
difference. And in paragraph, my lord, 50, paragraph 5, page 143 of our affidavit, we have stated that, my lord, the petitioner will be eligible for medical course, but not under PWD quota. There is a difference, my lord. Otherwise, my lord, we have given, every endeavor was made by all the sides, my lord, including this honorable court, to give some relief to all the, my lord, there were 8 cases, my lord, all appeared, my lord, twice. But, my lord, ultimately one got from this third time, my lord. report. Yes, my lord, we have done everything, my lord. Otherwise, we have nothing adverse against anybody, my lord, any student.
And one more thing, my lord.
Yes.
This NEET test was both for MBBS and dental, both. My next option will be dental also. If I see the darkness of the tunnel and go inside the tunnel, my lord, ultimately it will be dark all everywhere. But on the other end, dental will be good enough for
Dental
me.
is not less important, sir.
The dental is also good enough for me.
No, dental
One
is
second.
also not less important that in
Right.
other ठीक है dental में low impaired वाला भी चल जाएगा.
Right.
That can't be the case, sir. How can it be dental में? How can we take it?
That's what I'm saying.
Okay, dental
No,
is
he said
somewhat,
it cannot be given in a this quota. Had it been not in this quota, it could be, she could have been accommodated in other things. That's why in that context I am saying.
Let us close for audits.
Obligation.
Lordship.
You are appealing for all the responses.
No, my lord, only for the state respondents, my lord, there is the health department.
The department.
Yes, my lord, there are,
Central government also there.
my lord, central government is there. IPF for one.
Like it could be the house too. No.
1, 2, 4, 5, 6, and 8.
Close for all.
No. All right.
Item 62 to 68.
Lordship, regarding item number 63, all Assam Qazis Association, the government has already passed the Assam Muslim Marriage Compulsory Act, so this matter has become infectious. This matter will be closed with a liberty to file a special lordship.
And the concept of the petitioners have submitted that in these writ appeals, the
To take it, Anna?
Now, move to 63.
62, 66, 67, and 68, all are similar numbers. But some on is probably not similar, may not be able to come. 62, 66, 67, 68.
Learning concept of the petitioners have submitted that in all these, some repealing ordinance 2024 is under challenge. However, since the, what was the name of that show?
Assam Compulsory Registration of Muslim Marriage and Divorce Registration Act.
Assam
Compulsory Registration of
Compulsory Registration of Marriage,
Muslim Marriage and Divorce Registration Act.
Muslim Marriage and Divorce Registration Act
2024
2024 is already enacted. They want to withdraw these writ petitions with liberty to file fresh writ petition challenging the validity of the Act of 2024. If required so. Witness with liberty as great.
Item number 64, my lord, I am not withdrawing.
You are?
Item number 64.
You are not withdrawing.
No.
Why?
Because, my lord, we are, my lord, repealing act under challenging this, my lord, act.
Okay, you have challenged the repealing act.
Yes, sir.
Repealing act.
Yes, sir. There are, my lord, 2 acts, my lord. What?
Except 64 pending. Otherwise, this 62, 63, 65 to 68.
Ten to 65. Oh, I am appealing for it.
64 after 60. Item 44.
May I please? Lordship, this petition is about 16 students who have cleared every subject, even the final semester, Lordship. Now, after last time, Lordship, when the matter came up, your Lordship had, if some accommodation can be given as a one-time measure.
Yes. My lord, my instruction is this, my lord, regulation does not permit them to export that. My lord, no. However, my lord, your lordship order anything in the direction with that.
Regulation doesn't permit, then why you are asking that, or the court may pass an order, why?
No.
If you have sympathy,
No.
grant them an opportunity.
No, your lordship instructed, my lord.
No, why to instruct? If it is if they able to make out a case on law, then certainly will pass an order. Otherwise, if you want to, you are sympathetic about them, then grant them on their own.
Lordship,
Don't,
my lord, single judge, lordship directed to take instruction, my lord. Whether they could be accommodated or not. On this, on that, no, not single judge, my your lordship directed. My lord.
But
It is not reflected in any of the orders, however, during court proceedings, that was the.
if the regulations doesn't permit, we can.
Yes, Lordship, I'll try to make out a case. Lordship.
Out a case, then we'll admit it and then we'll grant, admit. No need to issue notices, parties are already represented through respective consults. Listed new courts.
Lordship, if Lordship gives because they are not able to take the admissions also, because.
Admissions, you have not cleared out.
Yes, Lordship, therefore, Lordship, I'll
You have not
seek
cleared the examination.
for a date, Lordship, that's all.
January,